Welcome, everyone. I'm Angelo Robles to Angelo Robles' Effective Family Office podcast, where I look to distill the best practices and best ideas of the world's most successful families and their family offices. I hope to provide thought-provoking opinions and feature amazing thought leaders to our listeners of the podcast with an eye towards the future of the family office. Today's subject is the legal needs of the family office. Now, we've covered estate planning and structuring issues a lot. That may be a little bit indirect to our conversation today, but I want to cover many other topics that surprisingly, in me doing these every day, that we haven't covered yet, and they're incredibly important, much more so than just family offices, but that's a part of it, of course, but a family enterprise, family residence issues with employees in their estates, family foundations. And really, this is an important conversation on labor and employment issues, but we're also going to cover, to kind of give a little bit of a hook, line, and sinker for this pretty long and I hope engaging podcast, the buying and selling of estate properties for families of great wealth. Aircraft, watercraft, exotic cars, art, and weapons. So we have a lot to go over today, including to some degree the dynamic of the attorney, the family office, and other advisors. So we have lots to go over, and we have the person that we're very excited to have on today. He's really one of the first attorneys I ever met of a prominent stature when I created Family Office Association about 12, 13 years ago, and is an honorary charter member of our advisory board that goes back to probably my second year in creating, back in the day, a Family Office Association. So our featured guest today is the attorney Tim Lappen. He's founder and chairman of the Family Office Group and Luxury Home Group at a very prominent legal firm, Mangels, Butler and Mitchell, LLP in Los Angeles. Tim, it's a pleasure to have you on the show today.
Thank you very much, Angelo. I'm honored to be here. We've known each other quite a while, and I'm proud of you, my son. You've done a great job in building this organization.
Well, you're very kind. I've always looked at Tim as being one of the true thought leaders legally, and then even beyond that in the community, and someone he's, arguably the most prominent attorney in the family office community in California, and his base in LA. And it's been a pleasure. And every time we talk, I'm the one that walks away the better of it because I learned so much. So we do have a lot to cover, Tim. Why don't we go a little bit broad initially just to lay the groundwork? There is a unique dynamic between the family, often the family principal, their lead attorney, which is often going to be someone like yourself, but you have the dynamic in my world of the family office or the family foundation. So how do you manage what I'm going to call preventative versus reactive legal work when working in the family office environment?
Well, that's a really excellent question to jump right in on. Here's the challenge. Lawyers can only do for a client what they know a client needs, and frequently only what the client asks for. And so I draw the parallel to your doctor. If your doctor only did what you asked for, you'd probably have a shorter life, right? Because you wouldn't have a physical unless you had a problem. And you wouldn't have that physical cover things that you weren't aware of. But clearly that isn't how it's done. And it sounds like I'm making a ridiculous comparison, but think about it. The doctor doesn't say, what blood tests do you want me to run today? He doesn't say, do you want me to listen to this, that, or the other? Because we all know the doctor knows more about us than we know about ourselves. And yet in the legal world, most people react to their lawyers as people that they call, like, I'll call you if I need you, which is fine, of course, in that environment. But the problem is, if that's all it is, then it only means that you'll get a call from a client as the lawyer if the client perceives a problem, which generally means it's become a problem. It's not a potential, it's not a future problem, right? So your preventative law is, first of all, much less expensive than curative law. But think about it. If you're doing a merger, for example, and at the end of that merger, you came up with a pot of money, and then you called another attorney and said, how do I get all this money over to my kids? That's a very expensive transfer. because now you're looking at gift taxes or perhaps grants or other vehicles. Whereas had the person discussed this with a lawyer a couple of years ago, they may have started gifting out or selling or granting out some interests in the business at maybe a discounted valuation, and they could have saved millions, sometimes tens of millions of dollars. These aren't tricks. It's just what the law allows people to do because of fractional interest discounts, for example. So the challenge for most lawyers is they can only know, if they can only help on the areas that they know about. And so the question is, who's between the lawyer and the client? Sometimes it's the client himself or herself. Sometimes it's an outside family member or non-family member who's running the office. Sometimes we're working through a different intermediary. It might be a financial advisor. It could be a concierge kind of person who runs the houses and the like and runs interference. So the challenge is getting to know the family well enough to know, for example, that they have a couple other houses where they have staff. So now we're looking at what are the laws of those other states where those houses are located. We have some family members who travel with staff. They may have nannies or tutors who go with them. So knowing that, I can help give them advice. And not to steal my own upcoming thunder on confidentiality agreements, but look at Michael Ovitz, for example, a very prominent and well-known and well-connected person who had a nanny who wrote a tell-all book. And when asked, why didn't your nanny have a confidentiality agreement? He said, I never thought about it. Because had he thought about it, he would have asked, and virtually any lawyer would have either said absolutely or let me check and then said absolutely that you need one. But he didn't know, he didn't ask, nobody told, and he had a major embarrassment because of it.
Well, that begs my next question, which is not an easy one. It's a little bit of a chicken or egg one, is if I'm a wealthy family, I probably have a little bit of bias to people that I hire or people that I use, like an attorney. Of course, they're not average, they're better. But how would I really know? So if I'm working with an attorney who's at a firm that has resources, but no one firm is going to be perfect on everything, and they do a complex estate plan for me, what knowledge do I have as a wealthy individual to really, really know if it's being stress tested and it's good? And the real honest answer in that example that I just gave, you really won't know until you're dead. And perhaps some time has passed and the estate plan has played itself out. In other words, how do you vet? How do you trust? And how do you have a backup plan to legal advisors that you have?
What a great question. You cut to the core. And so if someone says, well, I'll find out when I'm dead. So I say, well, of course, we give you a lifetime guarantee on your legal work, right? As long as it's for your life. Now, the answer really, it's a great question, because frequently when I get a new family office client, it started with a conversation where the principal said, I have the best lawyer in the world. And so I asked about that. How do you know? Good guy. I play golf, never cheats. Drives a fancy car, has a fancy office, the indicia of wealth or of success. Because the reality is most of us don't give a bar exam to a potential lawyer we're going to hire. Most of us don't delve deeply into the actual education of the doctor that we're seeing. What I say is that if you're working with a lawyer in a law firm, one of the benefits of that is that for self-serving reasons, in addition, lawyers in a law firm are very concerned about the quality of the law being practiced by their partners, because they're the ones who will be responsible if they mess up. So you have a constant vetting going on within a law firm to make sure that the work is being done properly. And with a firm, they have to have practices and procedures. And unfortunately, it also means they're going to have better insurance, which if the push comes to shove, they have insurance behind them. But you're absolutely right. I've been a client almost as long as I've been a lawyer of my firm and other firms that I've hired for different things. I'm shocked how hard it is, even for myself, to know who's good until I actually get into the meat of it. Because if I really knew the nuts and bolts of everything someone's doing for me, I do it myself.
Exactly. Yeah, that is one where there's not a great answer for. What I've seen some very, very wealthy families too do. I don't know if the lead attorney's like this, but the family honestly shouldn't concern themselves with that, is to go to another respected firm with a partner of some level of knowledge and stature and say, listen, I'm dedicated to the firm that I have, but it can't hurt to have a second set of eyes look at what they did for me. I don't want you to nitpick it like you're trying to get their business. But yes, if you have, well, I would have done this a little differently, or maybe they overlooked that, why don't you go back to them? And of course, you're paying that second set of eyes. They're not doing that for free, but they're not making the amount they would if they were executing all the work. I think in legal and maybe some accounting issues, that is an acceptable kind of second set of eyes strategy.
Yeah, I agree with that. And we do that frequently for other firms. And unfortunately for them, we end up frequently becoming the main attorney for those clients because occasionally they find out that they haven't done a good job. But the reality is, to say, I'm in Los Angeles, you mentioned we have offices in LA, San Francisco, and Orange County. But when you're looking at lawyers as a spectrum of quality, you probably, let's say that this is the spectrum of lawyers, but if you're looking at the most prominent firms in your community, the difference between the best and the worst lawyer in that community is, in that sector of the community, is probably very narrow. What you may find a big difference in, and that's only through the effort of working together, one, responsiveness. Number one complaint of lawyers is they're not responsive. Number two is soft touch, the ability to communicate, because sometimes it's not just the science of the law that's important, it's the art of the delivery, if I can use those examples. So, and I'm dealing with family members, and the principals want me to explain to their children, who are frequently 40s, 50s, 60s, sometimes 70s, what is and is not coming their way. It takes a soft touch. So you need, I think, a sensitivity as well. It's not just a function where you want a mathematician to add up a bunch of numbers for you. You need someone who can communicate it well with the family members and not make them feel marginalized or excluded.
For sure, that would be very important. Why don't we jump into, we're going to cover several specific subjects within legal, and probably the lead one we're going to discuss is a really important one. And I think so now during COVID-19, when you don't have the community of going into the office and seeing everyone and having your hands and eyes on what's going on, it's all remote. There are going to be some issues relative in a family office. So the family is going to make strategic hires, the CEO, the president, whatever they call it, down to what could be administration. What are some of the basics? I'm going to assume they're an employment agreement, privacy statements and statutes, and non-disclosures. But why don't I let you elaborate pretty extensively in terms of the type of agreements that people should have? And really, this is going to apply to, like I said earlier, family foundations, family enterprises. It's not just limited to the family office, but you may want to make your comments perhaps a little more specific to that. That's fine, Tim.
Yes, thank you. Well, so I wouldn't be a lawyer if I didn't have a caveat, a footnote, and an addenda to mention. That I am a California attorney. I have worldwide clients. Our focus is on the law of California. Other than estate planning, most of the law we're dealing with is a state interest effective law, sometimes even county or city law. And so our comments today, we're going to really be focused on what California lawyers are looking at, that the issues still apply to other states. The results may be different in other states. So having said that, employer relationships are paramount for so many reasons. One, the competence, the confidentiality, the availability, I would say loyalty. All of these things are really important in family offices, because at some point the office is going to disclose some information that is not, it's not public information. And how do they assure themselves that someone won't go outside the office in that conversation? So California, the other thing you need to know is what's the game that you're in, so to speak. If you're playing baseball versus football, the uniforms are different, the rules are different. California rules tend to be favoring employees,
Yes,
as they do tenants, as they do borrowers. It's just the reality. I'm okay with that, but the fact is you just need to know that from the outset. And so in California, what we start with is an interview, and if it's a very prominent family, especially it's for household staff, where they're going to eventually have to meet the family, we start with the remote screening. So it's done by someone who's not in the family. The applicant doesn't even know for whom he or she would be working, and they're meeting offsite either with a recruiter or someone in the family office who can't be traced back to the office. So they don't really know what they're going to be doing or for whom. They're going to be finding out, the interviewer is going to be finding out information about them. So they do a background investigation that has to be permitted under federal and state law. So there are forms to be used and signed, and it's important. And you can't ask certain questions. For example, a typical question used to be, have you ever been arrested? And that became impermissible when people realized you're innocent until proven guilty. So having been arrested is not the same as guilty of something. So people could not be asked questions like that. And other questions like bankruptcy and the like, there's certain things you can ask, but only for a certain period of time. So it's a little Byzantine, but people who do that for a living, background investigation firms, know how to create those forms, as do the lawyers who do that work. So once the person passed the background test, at some point, you're going to want to have an interview with that person. At some point, that person is going to be coming on property if they're going to be seeing the family house. So you want to make sure at that point, there's nothing about them that you're uncomfortable with. Their background is good. The people who talked, they gave as references, have come back very glowingly. And so we have them do an employment application that says that everything is true, and if there's anything in here that's not true, it's grounds for termination. So they have to take it seriously. The application has to be accurate. And then they are told they're going to have to sign a confidentiality agreement. And they're told they will have, in California, everyone is an at-will employee, but we want to make sure that people don't claim they had some other agreement. So we do have an at-will employment agreement that says what the deal is. And typically for our clients, it'll say people can quit whenever they want, and the employer can let them go whenever the employer wants, because it's an equal relationship. You don't have to give me 2 weeks notice. I don't have to give you 2 weeks notice. Which to me only makes sense. If you're an employer who's really unhappy with somebody, why would you want them to be around for 2 weeks after you tell them they're on their way out? I mean, so it doesn't make any sense anyhow. And then at some point, you're going to have they're also going to want a job description that gives people an idea of exactly what's required of them. Are they typical kinds of things that come up is what happens during a holiday, because in a normal working environment, that's when I get a day off. But in a family environment, that's probably they're going to have a 4th of July party, or they're going to have a Christmas party. And what if they travel? Am I working 24 hours a day? What's the deal going to be? So we make sure that there's a job description that describes what it is they're signing up for. Physical exam is a little bit dicey, because the physical exam, at least in California, can only be given for job-related issues. For example, if I need help because my elderly father needs to be lifted out of the bed and helped with bathroom facilities and the like, then I need someone who has the ability to lift and doesn't have back problems. But you can't do a general physical exam. The confidentiality agreement is an interesting one. They've come under fire during the Me Too period, because what they've served to do was allow bad actors to keep their bad acts private, and no one knew about it. And so it's going to be interesting to see how much of the confidentiality agreement survives. But when you think about a relationship, for example, right now, I have no expectation of confidentiality in this conversation. You've told me it's going to be a podcast, and Spotify and iTunes, it's going to be video. So there's no reasonable expectation. On the other hand, if you and I were having lunch, I would have a reasonable expectation you weren't taping me. If I'm working in your house, I would have a reasonable expectation that in my own room, if I'm a live-in person, that no one's taping me. But on the other hand, if I'm serving the family dinner or I'm sitting at the table with the kids, there's no reasonable expectation I'm not hearing what's being said. So it's not an invasion of privacy for me as a household worker or an office person to hear what's being said and talk about it. So we're not talking about trade secrets per se, but we're talking about things like family conversations about just what else they own or what they're going to sell or where they're going to go on vacation or what they like or don't like. I'm waiting for the book, The Bathroom Habits of the Rich and Famous. Someone talks some salacious information because people, they like to laugh at other people. And that kind of book about who brings the wrong snowsuit to the mountains and gets yelled at, they think that's great. It's sort of the Paris Hilton and the Nicole Richie, rich girls go to the farm. People like laughing at what rich people do, the foibles, so to speak. So the confidentiality agreement basically says things like my vacation plans, my assets, my business interests, my friends, anything that you hear in our house, we're agreeing to keep confidential. And anything that you see in writing, you can't make a copy of. Anything I give you in writing that needs to be worked on. For example, if I have someone coming to do an appraisal at the house, I'll have a confidentiality agreement with the appraiser, because I don't want the appraiser to have the right to talk about, yes, I was there for the Renoir painting, but I saw some Degas. You want to make sure they don't talk about what else they've seen. And so you can have that in there. And the question then is, what's the downside for breaking it? Well, first you make sure that it's for a long term. We usually use 80 years. And you need to make sure that they're clear the fact it doesn't last only as long as they're employed, because that's probably when you don't need it. Is when they're not employed by you, they're going to need it. And you want to make sure that you have some trial remedies, like a temporary restraining order or a TRO or a preliminary injunction or a permanent injunction. Because if all you can do is sue and win, then you're limited to money damages. And for many wealthy people, even if the nanny could pay them $1 million, for example, that's nothing compared to the embarrassment of having information spread. So you want to make sure the confidentiality agreement has some protections in there for what the remedies are. A couple more things. When we have large staffs, the largest family office household staff we work with is 40 people. When you have that many people, then you now have supervisors and workers, and now you have issues like sexual harassment that can be a problem. And unless you have a policy for what to do if there is a problem, then that problem can rise all the way up to the principals of the family. So for example, if I have a policy that says that if you're being harassed by someone, you should talk to your manager. And if your manager is the problem, you need to talk to this person. And if that person's the problem, the major domo of the house. And if that person's a problem to me personally as the family principal, then unless it's me or someone immediately below me, or if I've ignored what's been reported to me, then I have the potential liability limitation against me personally. The bad actor will always have potential liability, but you want to make sure it doesn't continue going up the chain. And then really one of the last issues I'll mention on that subtopic of labor and employment is performance reviews, because I find that when people have expectations that are completely unmet is where friction becomes a problem. So the person's been getting reviews every 6 to 12 months about how great you are, you're great, then you're fired. That's a problem, because they had no reason to believe that there was anything they were doing. Even though they are at-will employees, they can't be fired for an impermissible purpose, one that is constitutionally protected, like race and national origin or religious beliefs. So you want to make sure that people's expectations are met by those reviews. And then the other things I find a tremendous number of problems with. I don't mean to make this a soliloquy, so be sure to cut me off if I'm getting too granular. But wage and hour issues, big issue. People say, well, I pay my housekeepers a salary. Well, California has different classes of workers depending upon what you do, but typically workers have to be paid on the hourly basis. They have to get overtime if it's over 8 hours in a day or 40 in a week. Typically, there's some exemptions for people like home healthcare workers. There need to be time records kept. And very few families will use a time clock, but we always recommend a time sheet that the worker signs before getting the paycheck that says, I certify these are my hours, I certify I've taken all the required breaks, and then they get paid, and you have contemporaneous evidence that you didn't cheat them out of their wages. Because otherwise it's your word against the other person's, and one word against the other is just the definition of a trial. There's no prejudgment ability to end that. And then the other one we see a lot of problems with is people saying, well, they're independent contractors because they and I agreed. Well, unfortunately, it's really the IRS who decides who the independent contractor is. And if the person works only for me, that person's almost never going to be an independent contractor. A good independent contractor definition would be, is it like the pool person who cleans your pool? The person says, I'll be there a couple times a week, I'll bring my own tools, I'll bring the chemicals, I'll decide what needs to be done and I'll do it. A person who's not an independent contractor is probably the person who is your chef 5, 6, 7 days a week. And you give them a shopping list and give them a menu, and then they do all this work and they have no other worker they're working for. And then the subcategory of that is where they're coming from an employment leasing company. So I said, well, I don't have any employees, I lease them all. But the reality is in those cases, most of the time people are directing the worker. And so what they really have is not that I'm not their employer, I'm a joint employer. The leasing company and I both have potential liabilities. So let me take a breath here, because I know I'm very passionate about this work because it involves the things I've mentioned. If we did all of those for a family and created a family, an employment handbook, it might be a $4,000, $5,000, $6,000 project. And if they didn't do it, it could be $100,000 or several hundred thousands in damages and legal fees, even if they almost did it all right, or they had the best of intentions.
All very good points. So what you described is the family of wealth that has a household or multiple households, and likely, again, from drivers to chef to nannies to helping clean the house to a variety of different factors, is going to have talent or people helping them. It could be one person, it could be, like you said, 40 or more. It depends on the family. I think we went over in pretty good detail some of the ways you would want to vet for that and cover yourself from a legal perspective. Some of what you said is going to apply as well to a family that has a single family office. They're going to want to, now some aspects will be different. Probably there's a more formal, especially if they're a C-level executive, employment agreement, an employee handbook or manual. Describe some of the nuances that you would go a step further if it was more a family that creates an entity that effectively is a management company, their single family office, and the employees in the single family office.
That's an excellent question. And what happens is some people get a little too fast, a little too loose in that area, and they miscategorize people because, for example, on workers' compensation, you have to describe what it is they're doing. And we had a very prominent multi-billion-dollar family. When I drilled down on that area, I found out that the household staff were all categorized as secretaries in the business. And so all the maids, for example, because that's how workers' comp was being allocated. And that's completely incorrect. First of all, they probably wouldn't have any coverage for insurance because that's a completely mischaracterization. Your secretary is not climbing a ladder, not using chemicals to clean. There are all the things that could create problems would never come up for a secretarial position. So that's a huge mistake right there. And with regard to that specific situation where there's somewhat like a holding company that is the Daddy Warbucks family office, and then it doesn't do anything per se, but has these subsidiaries that run 5 different subsidiaries for 5 different core businesses. And then the yacht, the plane, every house is in its own entity. What we have them do is they will typically hire their accountant to have someone collect timesheets and then allocate the time spent so that the family office can justify why it's paying what it's paying, and then bill out to those various subsidiaries the pro rata portion of each person's time, if that makes sense. Because, for example, the CIO or the CFO of the core business frequently will be spending time on some of the sub businesses, so they want to allocate appropriately those costs, especially if those sub-businesses, as frequently as the case, have friends and family investors in that deal. So if I'm invested in this Daddy Warbucks venture that's doing a theme park, I'd want to know that they're not putting 100% of the overhead of the family office into my deal, because there would be an incentive to do that. They may not have thought about it, but you should just clarify it at the front end, how it's being done.
That is a very, very deep issue. I didn't even think about it from that perspective, but you are correct. I'm used to seeing sometimes things very black and white. You have a very formally structured, in my example, C Corp, owned by a living trust, SFO management company. You have the assets owned by this. It fits the lender versus IRS guidelines as a bit of an example from a couple of years ago. And you do things very, very by the book. But the reality is that is not how most family enterprises that have various entities and structures. And yeah, it gets really complex in terms of how that all ties together. Actually, I'm thinking that probably is the subject of a very deep future podcast. But in basically staying on the labor and employment part, if you're recommending to a principal, whatever, $1 billion principal, they identified someone, they want to be their CEO, they want to create a family office that will probably be whatever, 3 to 5, 5 to 7 people. And let's assume they're doing the legal structures correct. But from the employment perspective, what's the minimum that they need to have? Employment agreements, handbooks, non-disclosures. Right. And for high-level people that are 7-figure or top-level earners, are they going to have some kind of severance package to make it attractive for them to leave where they currently are?
Right. Well, I think everyone, regardless of wealth, people love saving money. And I don't mean in a illegal way, but they would prefer, all things equal, to be able to do something that's tax deductible instead of something that's just out of pocket.
Yeah.
So we need to make sure that we distinguish for our clients what the role of each of these people is. So if you have a housekeeper cleaning your house, it's pretty hard to claim that there's any kind of tax deductible part of that person's pay. But if you have someone who's overseeing the house, who's doing other things, there may be. So what we typically do, we like having an entity employ the people in the house, even if there are only 2, 3, 4 people working in the house, for one optical reason, which is the family and the workers see the employment is coming from the so-and-so corporation.
Do you prefer to see it as a CNS Corp or an LLC?
It's frequently an LLC, and we frequently will use that because then it has the formality that people don't see the nanny as just sort of like my young friend who works for me, which that person may be, but that person's employment relationship is characterized by a law that looks a lot like a factory worker or anybody else. There was I think it was Kobe Bryant who got sued by his chauffeur for employment law. But whatever, it was a wealthy person, well-known, and he said, I'm not an employer, I only have 3 people working for me. Because he had some belief that you had the magic number, say 5 people before you're an employer. I'm not sure what you were called before that, maybe friend with benefits of some kind, but whatever they were doing. And so you have to realize that this is a formal relationship. And by having an entity be the employer, there's also at least a potential benefit when a person is aggrieved and wants to sue. The lawyers, at least in California, who represent employees who are suing employers tend to be on a contingent basis. So anything that would help dissuade someone from taking that case is really a benefit to our client. And so we like the idea of having an entity. It certainly isn't like the normal entity that would say, my only liability is what's in that entity, because I'm the entity and I'm the one who's directing that employee, but it does help. And also would allow me to allocate some part of that expense to those various subsidiaries I mentioned. So if the major domo of the house is also working on 2 or 3 other things, maybe that person is involved in any business entertainment I do or something like that. So it allows for a better accounting. Because keeping in mind that paying someone through a business for a non-business related purpose is tax fraud. You can't deduct the payment for someone for something that isn't a business operating expense, right?
Yes, and that does bring up the whole thing of what I mentioned a little prior to the family office management company, quote unquote, the SFO, for sure, I hope, not being an individual, being an entity, like you said. Perhaps I'm going to make the point, and we'll talk more about this in tomorrow's podcast, for a C Corp, perhaps owned by a living trust. That could be one option. But you're correct to follow the lender versus IRS guidelines. Technically, the family office is a for-profit entity. Henceforth, it's getting the capability of deducting certain expenses relative to the agreement that that SFO management company has with the trustee or controller of the assets. And again, that's a very complex issue. There's lots of gray area. And even the lender versus IRS is just that one specific case where the lender family happened to have one, but that in theory doesn't automatically apply to everything. Let me ask a question from a little different perspective. And I don't mean this to be funny, but it's going to maybe come across this way a little bit. How do you properly fire someone?
Yeah, well, there are a lot of funny answers to that one, I suppose. And usually you use this kind of movement with your hand, I guess, is helpful, right? You're fired. But in all seriousness, well, first of all, hopefully it's not a surprise to the employee, because there's some documentation about problems. Even on an at-will employee, we like to see that there's some documentation of the problems and the family's being honest about it. Secondly, we want to be sure that the termination meeting has at least two people present in addition to the worker. So it's not my word against the worker's word about what was said, even though clearly if I had a second person there, it'd be someone I know and like and trust. So they say, well, yeah, it's just your friend saying that, but still, right. We like that. We as lawyers will frequently do that, but there is a downside, because if we are a witness in the matter, it makes it difficult to be the lawyer in the trial if it becomes a trial, because sometimes a lawyer is not a great witness and then people don't believe the case because the lawyer testifying did not persuade them. But we always ask a client to use a termination or a separation agreement. Now, again, we're looking at California law. On the person's last day of employment, that person is entitled to being paid up until that day and entitled to any accrued benefits that carry over, so unused vacation time or whatever. So you can't say to them, I'm going to give you your last pay when you sign this document. You can't condition them getting something they have a right to by having them sign a document. So the document has to have additional consideration, and it doesn't have to be a lot, but usually it's $1,000 or $2,500. And it does a few things. One is it reiterates the fact that they had an employment agreement that said it was at will. Secondly, it says that there's a confidentiality agreement in force that they signed before, and reiterate the fact that it's got another 78 years to go, and we attach a copy. And thirdly, we follow the guidelines. For example, for someone over 40, which is the definition of an older person in America, sorry to break it to you, but if the person's over 40, they have additional time to consider whether they want to sign or not. And once they do sign, everyone has a rescission right. So you want to make sure that the agreement says, you have this many days. When you do sign it, you have this many days to change your mind. And when all those times have passed, I'm going to send you a letter that says you had those days to think about it. You signed it, you had days to rescind, those have passed. So here's that extra check and a copy of that signed agreement. Again, is a very nice thing for a potential litigant in the future to show to a potential labor lawyer to say, I kind of already signed away all my rights here. And in California in particular, a lot of times the worker is not English speaking as a native language. And so if there's any doubt about the person's proficiency with language, we just did one the other day where we had 5 different people that we needed to let go and the family left the country. We translated it. We don't use just a friendly translator. We use a legal translator to make sure that the document gets the spirit and the letter of the language. And so they sign that as well.
Do things get messy when there's a formal severance policy in place relative to some level of debate, or is it very black and white and cut and dry?
You say get messy, do you mean is there legal uncertainty about it?
Yes.
Well, there's always legal uncertainty. California, United States, unlike other countries, some of which you'll have to prove your case before you can file it, anybody can file anything. And what makes it even more challenging is that anything that's said in a filing is privileged information. So I can say, I work for so-and-so and he was a crook and a thief and he did this and that and the other. That could be defamation if it's defaming of you as well as untrue. But in a litigation context, there is no defamation claim based on the filings to court because they want people to be able to say what really happened. So it's a matter of degrees. I would say with none of the documents we've talked about, with an application, a at-will employment agreement, a separation agreement, and the like, without those, let's say your chance of getting sued are 80% just because. I would say it probably drops to 5% with all those other documents. But it's going to depend on factors. I mean, how egregious is the behavior? Was there egregious behavior? Yes, I signed the confidentiality agreement, Your Honor, and I said I wouldn't speak outside of the household, but I was forced to buy drugs for the family. Well, that's a very different situation than someone who's just unhappy that they lost their job. Now they're complaining about illegal acts that are they're being asked to cover up. So that's challenging. You can't protect against that. But I would say it's again about making sure you have your expectations set. We've not had anyone challenge these documents because I think it's because they're clean. They're written in English. There's not legalese in them. And we make sure that people understand them. We tell them, get a lawyer to take a look at this if you need to. And we've not seen a problem come back because of it. The other thing I didn't mention earlier, but one of the things that when we have these companies set up to be the employer, we make certain, and even if they don't have a company, but especially if they do, that they have insurance. The Employment Practices Liability Insurance, called
Right.
EPLI, is critical. And frequently your EPLI coverage, people will give you some advice on how best to handle your employees and how best to terminate your employees. But I think it's a combination of skill and luck to not get sued because you can't really predict. It's almost like a marriage. Like the more you know going in, the less likely to be a problem later. And you find out that you've hired someone who's a pathological liar. That could be a problem. And no matter what you do, you're going to have a problem. And even on termination, you'll probably have a problem because that person is showing the person's true character, and it probably will come out then as well.
Related to that, how about if you have I'm going to go back to the great American football coach, Bill Parcells, who basically said, as a coach, if I'm going to be the cook, I want to buy the groceries, meaning he wants to be the general manager too, which in time he would become, by the way. So if I'm now the new CEO in a family office or the new household manager, maybe I have a different way of doing things and a different standard. How do I give people that are currently there fair treatment, but I am going to hold them to a higher standard? Do I update the agreement, the employee manual? What the reality is, probably half the people are not going to either want to stay or I'm going to let them go within 60 days, but I want to give them a fair chance to improve. Mm-hmm. How legally would you structure documents to address kind of that new head person in charge that wants to, I'm going to be positive and say up the ante on the services to the family?
Right. Well, first, your questions are excellent. It's clear that you've been steeped in the family office milieu for years. And so that's a great question. And so in California, again, we are an at-will employment state. So that the fact that someone can be terminated at any time, you can also change the terms of the employment at any time.
Yes, key point.
So you do have, it's not, typically you're not dealing with people who have employment agreements. If you do, you have to look at the agreement. Does it say, as it should, that you have the right to reassign or give somebody a different job description? Secondly, we didn't want a family relationship with their staff to change with each new supervisor. It'd be too much of a whipsaw, I would assume. And I've not seen that happen in a great degree, but it is not unusual for it to happen when someone first becomes a client and they haven't had any kind of structure before. We typically tell them to lay the blame on the lawyers. They like doing that. That my lawyer is telling me I have to do this, and or my insurance company is telling me I have to do this. We will either script it out for the family to tell the workers, or we will meet with them and the workers to explain what the changes are and why, and give them plenty of time to think about it, to say, you know, this is something that's really important to us for these reasons. It's not just some sort of a flippant idea like, well, I think we'll change this now and cause some grief over here. So that people, I think if it's explained properly, it's not really seen as a worsening of the employer-employee relationship. But then, yes, we do have them sign agreements. And in fact, if the law changes and we need to update things like the right to arbitrate a case or who pays for the arbitration, that seems to change almost with the wind, the way it seems to keep going back and forth with the law about whether you can force arbitration or can't, and who pays for it and the like. And so when we update it, when the law changes, we contact our clients and say, this is a change and we suggest an addendum to the existing agreements.
And a reminder to some of those that may be listening in live, there's so many issues we could cover with a wonderful attorney like Tim and we just touched on it ever so lightly and directly, how to structure a family office, how to structure the ownership of the assets, to some degree, estate planning issues. We can't cover everything with Tim. Some person just sent me a text that I know, a friend, like, hey, how come you're not covering... His question was more on executive benefits, on qualified plans, on bonuses, on profits, interest. That's a different discussion dedicated for high-level, C-level executives in a family office on executive benefits. And that might involve a legal professional that we'll do in the future, but there are people that specialize in executive benefits and some that have a bit of a sub-expertise in effectively single-family offices or very small private companies with very high-level employees, but a different subject, or we'll be here for 3 hours with Tim. Let's move on a little bit from labor and employment. I think we covered it relatively well. We do want to have you back and do maybe a part 2 to that, but there are other areas besides structuring and estate planning that are going to be legal areas in the family office. You have tremendous experiences with wealthy families that buy effectively global estates. If you could talk about the perspective from the legal side, you hinted at one of them already, probably owning it inside a corporate entity, but tell us more.
Yeah, that's a very interesting area. And not only in general has it been, but because of the global uncertainty and then the pandemic, the desire of people to have a California lifestyle. You know, you may have seen some of the somewhat humorous YouTube videos where it shows a person quarantined, say, in a town that's very vertical, and they're in a 900 square foot apartment, and then someone who's got a backyard and a pool and a jacuzzi and a barbecue outside. You know, it's very easy to sequester in the California lifestyle where basically you have outdoors constantly. So we've had a fair number of non-California, non-US buyers come into California to buy property, because for a lot of reasons. I mean, one is it's certainly lifestyle. Another is it's probably a really good offshore bank account. But and specifically to answer your question, when people are buying real estate in California, they virtually always are using a real estate broker, and they're using an escrow. And if it's over a few $1 million, the odds are they're going to use a lawyer at some point. But the mega properties we're dealing with, and so far the most expensive is $250 million. If you're buying a house for $250 million, almost anything is going to be important. And by definition, right, because everything about it is expensive. Many of those properties have been cobbled together from various parcels and other houses that were nearby that got torn down, and they created a mega lot that's several acres. And so land use will be an issue. What is the land use? First of all, do the people developing it do it right? We look through the county, we have land use professionals in our office to find out, was it all done? And are there any restrictions on how it can be used? For example, is the driveway something that the buyer owns, or is it just a right to use the part of the neighbor's land to drive up to the property? And what are the conditions of using that land? And we just need to know. So you're looking, it's not about the law per se there, it's about what do the documents already say about that? But the other thing is that we have extensive network of inspectors. That we might have 20 different inspections of the house, including things like the soils. Are they expansion soils that move in with the weather changes? How are they seismically? Because the house built well for that. And sometimes they have to do some pretty extensive testing to find out the answers to those questions. And then what is frequently families are going to want to have then an owner's manual, so to speak. So like with your car, you change the oil every so many thousand miles. What do you have to do to maintain this property? Because it's going to be very sophisticated with a lot of electronics. They might have special irrigation and water control methods around the property to make sure the water stays off the property. We have a client like that where they had every 6 months they had an agreement with the city that they would the client would who owned the property would have to clean out certain water ways to make sure the water didn't back up and create problems for them or neighbors. One property actually had an agreement that the owner of the property had to insure against land failure of the property below, and they were going to give the city an indemnification. So it's remarkable how many things can be added, because it's really up to the imagination of the owner to put those restrictions in there, or the city to try and lay off the lane before approving a project. So we'll look at things like what they're called CC&Rs, the covenants, conditions, and restrictions. We'll look at the homeowners association rules. We'll find out, for example, they're talking about doing a tennis court. Are you allowed to put a tennis court in? Are there noise restrictions from neighbors? Maybe it has to be somewhat below grade. Can you put lights in? If you can you leave them on at night? There may be lights permissible, but only until 7 p.m. So you need to find these things out. Then you've got questions about privacy. We have some clients who I would say use level 10 of privacy. No mail comes to the house. It all goes to the business manager. And no property is in the person's name. As you mentioned, we use a blind trust or any kind of document that, depending on what works for their overall plan, but it'll typically say it's owned by the 123 Elm Avenue LLC. And then, of course, the manager won't be the owner. The manager will have to be someone who can't be traced to the owner, because otherwise you just know where the owner lives. So the manager would typically be a lawyer or a law firm or an accounting firm, so that the property ownership is just an entity addressed over there in Century City. The insurance we already talked about in general, the same thing would be true here. And insurance is very expensive in Los Angeles now. I have a client.
Very. Because of the fires, mainly.
Well, because of the fires, right? So we have a client in Bel Air, $7 million house. It's $80,000 a year for insurance. That's a tremendous amount of money for that house, for a house of that price range. But that's sort of where it is right now. So you need to know, are they going to surcharge your property, even though you don't think you live in the woods? They think you live in the woods, and they're going to charge a lot for it. And then what are the boundaries? We need to get a survey. Is there a dispute with this neighbor or that about where the wall is, and whose wall is it, and whose trees are those, and who gets to cut them? Do you have the right to cut them down to keep your view of the ocean, or do you not? And that can be both a private right held by the association or held by a neighbor, or it could be a public right based upon view easements or a lack of thereof. People think they have a right to a view because there was a view when they bought the house. That isn't the case. If you want a view across your neighbor's property, you better own that property or take a look at the agreements to see if something's there already. So it's those kinds of things that we look at. So you're looking at the physical property, you're looking at if it's been done properly, looking at what can be done in the future. We looked at a house for a very well-known person, and it was a gorgeous house. We found that there was a road easement behind it that was within 5 feet of their kitchen window. Now, this was a wooded mountainous area, but it had the potential for a road that would cut through the mountains that had never been vacated. And look, is it likely to happen? I have no way of saying, but it's still on the record, so they need to know that. It's not my risk to take, but
Right.
the people before it didn't even know about it. The people who own the property were there and happy to find out it was there. They agreed. It wasn't my interpretation, it was the truth. So much of it is just good investigative work. I guess you'd call it almost like due diligence. You just need to know what you're doing and make sure that you buy the property properly by doing all the necessary inspections and inquiries.
What are some of the legal issues, ramifications, I guess federal and state specific to you in California, of the ownership of weapons?
Well, I'm not an expert in weapons, but I'll tell you that we've had clients with weapons collections, some of whom changed states. And so you've got state and federal laws that apply. And this client in particular, they're all historically important weapons. They were owned by, like the first governor of California. The client had a Gatling gun, which is a precursor to a machine gun. He had a cannon from like Civil War era. These are very valuable pieces. And we were able to get approval from the federal government that none of them was on any kind of confiscation list and all of them could be moved, and approval that it was okay to bring them into California. Interestingly, we ended up years later, the client was deciding to lighten the load on some of the ownership of assets and decided to sell the weapons collection. And we were very successful in getting in touch with the top weapons auctions company and got them to sort of bid against each other. And we took the one who had the highest bid of what we likely could get and asked them if how sure they were that they could get that kind of number. And they said they were absolutely positive that'd be the minimum. And so we negotiated with them and got the minimum payment up front from the auction company and then gave them a percentage of the overage. So that worked out wonderfully. And then we had a weapon that came up during the auction that somebody said was promised to a museum, and the museum said, you can't sell that weapon because so-and-so promised it to us. Well, as it turns out, that's really a claim they have against that person's estate, not against my client, who's a bona fide purchaser. There was nothing ever recorded to tell him he didn't own the thing. There was no future right anywhere. So, I feel bad about it because people get upset with lawyers for how it's been like tricky, but how would you know? If I go buy a weapon from someone and I do a search and don't see any restriction that's been filed anywhere to say that that person doesn't own it, it's registered to that person. I'm talking about collectibles. I don't know anything about buying a gun for like protection kind of weapon law, but if I have no way of knowing and this person has documentation showing that he bought it from an auction that's a well-known auction company, has had it consistently from the purchase, there's no reason to believe someone else had that right. So what museum should have done is recorded something to say they have a right to it and provided documents that would have shown that. And then you have to still keep track to make sure that you assert your rights when you see that it's coming up for sale.
And let's move on a little bit to something that I believe, if I remember correctly, you have a bit of an affinity for, and that would be, how about a wealthy family that has an interest in antique, unique, exotic cars? Are there specific legal ramifications that the family or the family office should be familiar with?
Well, I love car questions. I mean, for one, as I think you know, I've been the fine autos editor for Haute Living magazine since 2012. And so I currently have 5 cars in my driveway to be driving around and reviewing, including a new Polestar that most people haven't even heard of. It's the new Volvo brand that has a hybrid $155,000 Volvo Polestar.
Wow.
But in answer to that question, I've gotten so many calls from wealthy individuals who know I'm into cars, and they'll say, a friend of mine told me I could turn my car collection into a nonprofit. And I say, well, yes, you can. But if you do, that nonprofit will basically have one shareholder. And they say, yeah, that's me. And I said, no, it's the attorney general of your state who will be the one shareholder. And the Attorney General is going to say, what's the benefit that I'm getting out of this after all? I mean, why exactly do I get to give you this nonprofit status? Are you going to have classes? No. Are you going to have a lending library where you can lend the cars out for public benefit? No. You can have tours, and I don't want people coming to my house. So, you know, you're not going to be able to have a nonprofit. You could have a future gift you could make and then create a nonprofit in that way that you get the use of them during your lifetime, but you then don't own them. So that's one issue, of course, is that like any other tax issue, there's got to be, it has to make sense. It makes no sense to say it's a nonprofit, but I continue to own them 100%. And at my life, life ends, I'm going to give it to my kids. But in terms of buying cars, there's also the issue of when you purchase something, you have to pay sales tax unless you have an exemption because you have a dealer permit, and we've gotten dealer permits for some of our clients. If you're bringing something into California, you have to look at whether it needs to be qualified to be driven here or exempt because of some historic value. If it's coming from another country, it's the same as if it's art from another country. You have to prove that it wasn't stolen, although cars, there have been very few cases of stolen cars in that level because they get known. But in the art world, as you know from that's a really major problem. And so we'll help people sometimes have them route the vehicle to different countries so that it goes through their own customs and it goes to sort of a bill of health as it goes through there on its way to America. But you need to be sure that you're dealing with whom you're dealing with. Typically, the biggest problem has been gray market cars that were never certified to be brought to California, not brought to the US. And then the registration's problematic. We had a client with a Ferrari that was not qualified in the US, and he was able to get around it by doing a lot of retrofitting that let the car pass smog tests. But when the smog tests changed, it used to be where they would have a sniffer in the exhaust pipe that would just check to see if it was clean air. It changed to being one where you plugged it into the electronics of the car, and the car electronically communicated with the tester. Older cars don't have those electronics. The car wasn't old enough to be a historic vehicle, so it still couldn't be registered in California because it couldn't pass smog tests because the smog tests couldn't communicate with their car.
Wow.
Yeah,
that's pretty nuanced. We would have dived into art, but we're actually going to be covering that next Wednesday, July 15th, with an attorney, an auction, and perhaps an SFO executive who deals with art for the families. So we'll save art for a different time, but in taking it a bit to the home stretch, talk a little bit about aircraft opportunity and ownership and the legal ramifications. We all hear about, should I own it? Should I lease it? Should I do a net jets? How do you compare the options from a legal perspective, and what are some of the legal ramifications?
Well, it's certainly topical, isn't it? With some high-profile accidents that have happened, the legal ramifications can be gigantic. You can imagine if a plane crashes with people aboard and into something where people are located, the liability potential can be huge. So, although it's not, I typically hire an expert in aviation law if it's something more detailed than that. California will charge a sales tax, and as I'm always honest, I'll tell you, I don't recall now if it's now still a year. It's changed, the time difference has changed as to how long something has to be kept out of California. For example, yachts that were brought into California upon purchase would get a sales tax or a use tax that could be 10%. And so people would take the yacht, but they wouldn't take delivery in California, and they'd put it in Mexico in a marina that's meant just really for Americans who are keeping their yachts offshore. And the same thing was true of airplanes. You'd make sure, even if you owned a fractional interest, that the exact plane you own the fractional interest in didn't come to California during that exclusion period, so there was no tax. But you could still, if it was, say, a NetJets or citation shares or any of those, you could still use the service, but you would make sure your particular plane didn't come in. Now, there's different ways of registering planes in terms of what they can be chartered for, and some allow entities to be owners and some don't. So what we end up doing is using counsel who were knowledgeable in that area, because probably the main question that most people have is, what's the best plane for me? And so then you come back with, well, what's the payload going to be like? How many people? How much luggage? What's the altitude you're going to? What's the height that you need to get to land at, say, the airport at Aspen? And those kinds of questions come up a lot. So there are airplane brokers who are very knowledgeable about that. And then you look at the use of it. Some people just like the idea of having their own plane. And like they say about, is golf good for business? Well, golf is really good for business if you love golf, because you want to play anyhow. I've heard that said about helicopters. Are they really economical? Well, they are if you like flying a helicopter and you want to have it for your business. But what I've seen it for clients who say are real estate developers who've got at any given time 5 or 6 major projects in around different places in California that don't have their own airport or commercial airport. And that works really well for them. And that's a business expense. But the IRS is reputed to be very careful about doing an audit on any private aircraft use. And because you figure, well, I'm going on a business trip and this person coming with me is going on a business trip. What difference does it make if my spouse and kids come with me? Well, it does make a difference. And they want to know what percentage of the trip is actual personal and how much is business. You get into the really arcane area about if the person has a legitimate, verifiable security need to fly private, then sometimes that's a business expense. But it's very arcane. The area has to be looked at very, very specifically. After the people decide what they want to do, whether they want to buy a fractional or a whole plane or whatever, they really need to talk to counsel who just do that work, because the regulations and the taxes pertaining to that really require an expert, because the odds are it's going to get looked at.
That is for sure. And there are certainly, like you noted, aviation-specific attorneys, and we're probably due to have one of them on the podcast sooner rather than later. Well, there are some things we're leaving a bit on the cutting room floor for the essence of time. One of them indirectly popped in my head: the challenges with people that have property ownership, specifically a residence in your state, which is a very tax-heavy state and very aggressive going after people. But that subject, watercraft and some SFO structuring issues and estate planning, again, there's so many legal issues. We'll have to wait for a bit of a different time. This went by so quick. I don't believe it, but it's always great to connect with you, Tim. I thank you so much for your time. In doing a close, we would certainly like an opportunity for people that are live or watch this on YouTube or hear it on a podcast that would like to follow up. How could they learn more about you and your firm, and how could they connect?
Well, I appreciate that. And I would also say for future topics, succession planning is a huge one, and the estate planning components of the family business, and especially when you have more than one kid and one kid or more are working in the business and one or two are not in the business, what do you do with them? So I think those are all important topics. But in answer to your question, the website's easy. We've been on the web since the beginning of the web. It's JMBM, Jeffer, Mangels, Butler, Mitchell. So www.jmbm.com. And my email is TL, as in Tim Lappen, @jmbm.com. And I'm happy to talk with people. Obviously, depending on the question, I might need to do a conflict check to be sure that there's no challenge there, but
of course,
certainly with an audience like yours, I'm happy to talk with people and see if I can be helpful, because as you can tell, I really enjoy working with people with a really wide variety of topics.
That's for sure. And everyone, it's been great to have Tim Lappen on the show. And by the way, Lappen is spelled L-A-P as in Peter, P as in Peter, E-N. And I'm going to do a little bit of my close now, which I think I could do in about a minute. Everyone, I'm Angelo Robles. I'm the host of Angelo Robles' Effective Family Office podcast on iHeart, Apple, Stitcher, Spotify, and other platforms. My YouTube channel, where some of our Zoom videos go up to, is simply Family Office. So if you pull up Family Office channel on YouTube, that should be able to find it. And I'm also the founder and CEO at Family Office Association, a global membership organization dedicated to families of great success and their single family offices, providing a significant amount of original proprietary content and thought leadership, hosting global programs on hold because of COVID. But like my members have told me, you went from doing 12 events a year to doing, about 150 plus, given that multiple times per week I host often daily, or sometimes like this week, Thursday and Friday, 2 a week or 2 a day. So we do lots of virtual and digital meetings and lots of other initiatives, from our master classes rolling out this summer to some level of consultative services and tabletop simulation, disaster planning, red cell strategy planning. My members have gotten a whole bunch of communication from me, but those of you that may be listening in a podcast or as a guest, certainly feel free to learn more. FamilyOfficeAssociation.com, and my preferred email is angelo@FamilyOfficeAssociation.com. Thank you to our listeners, everyone on YouTube and podcasting that will hear this in the near future. And of course, a special thank you to our wonderful guest, Tim Lappen. Tim, thank you so much.
Thank you, Angelo. Great seeing you and talking with you.
Always a pleasure. Thank you. Stay safe.